All right, good morning. It looks like it's 10:50, so it's time to begin our lecture today on the preservation of ESI. I appreciate everybody who could attend in person, and for those who couldn't, no problem. Hopefully the recording will be up shortly after the lecture today. I want to talk to you guys today about preservation of ESI, which is a very broad topic, very important topic, and we'll talk about why it's so important as we get into it a little bit more. But the first thing I want to do is sort of distinguish between two concepts that are related, but not exactly the same. And to be knowledgeable and to appear knowledgeable about the subject, you really need to know the distinction. It's quite often that you'll run into attorneys who don't, and it can cause confusion. And I'm going to start off by revisiting the EDRM. And this is the roadmap for e-discovery as it's practiced today. And so I'm always going to start us off, show you where we are on the map and how the subjects that we're talking about sort of relate to the overall process. You'll see a box called preservation. It's really sort of the third stage of the EDRM. And preservation, as you see it here, relates to the preservation of documents for litigation. So very specific, preserving documents and evidence for a case. There's another concept that we're going to talk a little bit about called retention, which is in a way preservation, but that comes back several steps earlier in the information management stage. And I just want to distinguish between retention and preservation so that you'll have a clear understanding of it. And when you communicate about these issues with other attorneys or with your clients, you'll be on the same page with them or can help distinguish the two. So we're going to start off with a little bit on information management and then move into preservation. Let me distinguish them first. Okay, retention versus preservation. Retention of documents or evidence, ESI, is generally considered part of information governance, which is a very big issue for corporations in particular these days because they have so much data to deal with. I mean, literally millions upon millions of documents generated every day in the form of emails, text messages, and so on for many clients. And so a whole sort of cottage industry is developed around the concept of information governance, and a big part of that is retention. Retention just means how long what documents is a corporation or business going to keep, and for how long does it intend to keep them? And then what does it intend to do when it no longer needs them, such as deletion? And how do you do that according to a policy that will make sure that you're keeping the records as needed by the business, and so that you don't create the appearance of having destroyed evidence if there's ever litigation. Preservation, on the other hand, is, like we said, related to the litigation. So the differences between the two: retention is very proactive. It's before there's any notice of litigation, deciding what we're going to keep for how long and what we're going to get rid of and how we're going to get rid of it, and reducing that to a policy. Now, like most any corporate policy, having a policy you don't follow is worse than not having a policy at all. So it is a burden to the businesses to have it, but it's a small burden compared to the burden of retaining all of the information that's being created. Preservation, on the other hand, is very reactive. It's when there is a reasonable anticipation of litigation, what does the company do in response to that anticipation of litigation? So there's the two ways that those two terms of art differ. Retention is driven by business focus largely. How much data is being created? How is the company going to preserve that data? Why is it going to preserve the data? How much does it cost? What's the benefit? You know, this day and age, there's a concept called big data. You'll hear that term thrown around. Sometimes it's used incorrectly to just refer to large amounts of data. What it really means is companies that are collecting large amounts of data for a business purpose, and they're analyzing it. And there's a real easy example that you're probably all familiar with, and that relates to Amazon. Whenever you make a purchase on Amazon, Amazon is recording that information. So the next time you get on Amazon, you're going to see ads or suggestions that are similar to or that they believe will appeal to you. And they do that for all of their customers and all of their purchases, and they mine those records to find out what items are being purchased, which types of people, what demographics are purchasing what. And Amazon keeps that information, and they study and analyze that information because they can use it for their business advantage. And so although there's a great burden of keeping all of that data, they're profiting from it. And it's not just Amazon, obviously, lots of businesses are doing the same types of things. And so there is a business benefit to keeping it, and that really drives retention. Some industries are regulated by government, and there are actually requirements to retain certain records. Financial services, in particular, banks, are a really good example right now. And so they're required in order to do business to keep certain documents for a certain amount of time. And so there's a business driver to the retention side that it doesn't necessarily deal with litigation. Preservation, on the other hand, is strictly focused on litigation. What information do we need to keep for this particular piece of litigation or a group of related litigations? Retention policies are intended to reduce costs, believe it or not, even though there's a little bit of bureaucracy that goes in managing the documents, the information governance itself. The goal is to be able to delete data at the end of the day that you don't benefit from. And that can save money in a lot of different ways. The obvious one is just the storage costs of saving so much data. That really kind of pales in comparison, in some instances at least, to some of the hidden costs. And a good example, and this does relate to litigation, is a company that preserves everything. It just stores all of their data. When it comes time to do litigation preservation, has a lot more data that has to be potentially preserved and analyzed. And you can imagine paying an attorney $200 an hour to sift through 1 million pages of documents. It's incredibly expensive. And so by only keeping the documents that the company needs, or that it has a business case for keeping, it reduces the amount of money it's paying outside counsel or even inside counsel from having to go through and review useless documents. So there's lots of ways that a good retention policy reduces costs. Preservation, on the other hand, is a cost creation. It's not something that clients like, because it's basically creating a burden on them to save documents that they might not otherwise want to keep. And so it's saving those documents for the purpose of being reviewed and potentially produced in litigation. So it's seen as a cost creator, whereas a good retention policy, information governance plan, is seen as a cost reducer at the end of the day. And retention policies are continuous in nature. So basically, this is the policy that the company is going to follow going forward until it's changed for each type of business document that they deal with. And what you'll see is an email retention, for example, is really an easy example, that they're going to keep all emails for 6 months, and then they're going to delete them. So they only have 6 months of active email, and they do that and they keep it going forever. Although a lot of times there's ways, if there's an email that's important that you want to keep beyond that retention period, the company will have ways to do that. Preservation periods are finite in term. They relate to litigation. And so there's, from the anticipation of litigation is when the preservation duty begins. And once the case has been finally resolved, including appeal, then the preservation duty will be removed, and that documents that were being preserved for that purpose can be deleted. So there's a finite term to preservation. So a couple of ways to help you distinguish between the two terms. Although they're related, they both mean keeping documents. They're very different in the way that they're applied in the legal sense and the business sense. We are going to talk and focus on the preservation side today, but remember, retention is important. It's very important to your potential clients one day, and being able to advise them, guide them on retention policies is likely going to be a part of your practice. And keep with an eye to preservation, you can really help them save a lot of money on the retention side. There are entire in-house legal teams now dedicated to document governance and retention. So it's a whole new sort of world of business for lawyers. Just to give you an idea of how all of it fits on the information governance side, then we'll get into preservation specifically. But this is from the same group, the EDRM. They created a very colorful, it looks like a Simon Says game for information governance. But it does show you, I wanted to show you the different components that go into information governance versus preservation. And you'll see the biggest piece of the pie is business profit. How can the business, how does the business benefit from or profit from the information that's being created or preserved? And that really is, in large case, the driving force behind retention, for sure. But there's also privacy and security concerns, IT concerns, what can we get rid of, how much does it cost to store, risk management concerns, and then legal. Preservation really represents the little red wedge that you see on the left side of the chart. And so it's a much smaller piece of the larger retention component. And the idea for most corporations that deal with information governance is how do we make this make sense for us from a business perspective? We know that we've got legal risk, we've got these preservation duties, but at the end of the day, our job is to make money, and we've got to make decisions and considering all of these components. And so information governance is much more than a legal component, although it's usually driven by the legal team. It also involves voices from, there'll usually be an information governance committee headed up by legal, but we'll have representatives from each of the branches that you see here, or whatever that company has, to discuss what documents do you have, why do you have them, do you need it, and for what reason, and how long should we keep it, what is the legal risk of getting rid of it. And those types of decisions are usually reduced into a policy that the company can follow. Policy is usually maintained by the IT department if it's an automated ESI system where they can delete data or archive data remotely. One of the things that we do in our legal practice related to e-discovery is to go into our clients and help them develop retention governance models or retention plans. And it's really a matter of asking the departments, the different department heads, what documents do you use, what documents do you create, where do you keep them, how much do you need, how long do you need to keep it, what are the legal ramifications. We do research on that to let them know. Sometimes they don't. And the ultimate result that comes out of that is a policy that has to be followed. And failure to follow your policy is one of the things the courts will look at when it's trying to decide whether or not this particular piece of evidence was deleted intentionally or unintentionally. If it's a document that your policy said should have been kept and it was deleted anyway, even if it was by accident, you can rest assured your opponents will argue that it was done intentionally to prevent them from having that document in the case. So all of this relates to e-discovery and preservation. I just wanted to show you, give you an overview of how preservation fits into the bigger picture of information governance. All right, so with that said, let's focus on the duty to preserve data as it relates to e-discovery and litigation. First of all, the duty to preserve evidence is a common law duty. There's not a rule in the federal rules or even in the state rules that says you have to do it. It's presumed that once the duty arises, though, for litigation, you do have a duty to preserve relevant information. And a lot of the dispute or litigation over this is, when does the duty arise? Because corporations, businesses, even individuals delete data every day. So at what point have a duty to keep that data, to stop the deletion? And the general buzzwords are reasonable anticipation of litigation, although it's been articulated lots of ways. Constructive knowledge of future litigation, credible threat of litigation, something more than the mere possibility of litigation, whether a reasonable person under the same facts would anticipate litigation. They're all trying to get at the same thing, which is, did the party, whether it be a company or an individual, did the party know that there was going to be a dispute where this information might be relevant at the time that they deleted that information? So it's a very fact-specific analysis. It will vary case by case, and quite frankly, judge by judge. And as attorneys, it's going to be your responsibility to persuade the judge one way or the other. And quite frankly, the attorneys who know e-discovery, who are familiar with this turf and understand these terms, are going to be the most successful at persuading the judge to see it their way. And so the attorneys do make a great deal of difference on whether establishing when the duty to preserve arises. It's something that the judge will decide as soon as there's a litigation dispute. I have a case here. I try not to retread over this information that you're reading too much. This particular case is not going to be in the book. This is a Georgia case, and I know most of you will practice in Georgia, although maybe not all of you. If you don't, that's okay. Just be aware each state has its own duty to preserve trigger. And in Georgia, there was a dispute about when that trigger occurred up until this summer. The Georgia Supreme Court resolved it in a case called Phillips v. Harmon. And this is an interesting case. Prior to this case, there had been a split among the Court of Appeals decisions, which there's a joke that no matter which side of the issue you're on, there's a Georgia Court of Appeals decision to support you. Phillips v. Harmon seeks to resolve that related to the duty to preserve. Traditionally, the rule in Georgia had been that the duty to preserve only arises when the defendant receives actual or constructive notice of litigation from the plaintiff. So there had to be some indication from the party that was going to sue that, hey, I'm going to sue you or I might sue you. And that didn't have to be a complaint or even a demand letter. It could be a threat, but it had to come from the plaintiff. And Phillips v. Harmon said, no, that's not going to be the rule anymore in Georgia. And after this case, basically, that the authorizing the courts to look at the party's post-injury conduct to determine whether or not it was under a duty to preserve. And this case is a great example of it. It relates to a troubled birth. The mom had given birth to a child who had suffered neurological injuries resulting from oxygen deprivation during the birth. And the hospital kept a fetal heart rate monitor that produced paper records while the birth was ongoing, and the nurses would make handwritten notes on the written record, which they would later go back and reference when they were writing up their final report, which was all kept electronically. And the hospital, because the paper record itself wasn't an official health record in their retention schedule, they only kept them for 30 days after each birth. Presumably, the nurses would write their report within that 30 days, and there was no longer a need to keep the actual paper printout. And the hospital, in this case, followed its policies perfectly. First of all, there was a troubled birth, so it launched an internal investigation to find out what happened. It notified its insurer, and it contacted its attorney. The hospital had no idea, had not heard from the plaintiffs yet whether or not they were going to be sued, whether there was any issue. They were just following their troubled birth policies. And pursuant to their document retention policy, they destroyed the paper record. And of course, when that came out, the plaintiffs argued that the nurse's notes could have contained relevant information that's been lost, and they asked for an adverse inference. And the trial judge said, no, we don't find any evidence that the hospital had any notice that you were intending to sue them at the time they destroyed the record, and so we're not going to give the adverse inference. And the Court of Appeals upheld that. And the Supreme Court in this case reversed it and basically said that even though the hospital had not heard from the plaintiff in this case about litigation yet, it took certain actions that should have put it on notice that litigation was possible, or were evidence that it was on notice, and that was launching an internal investigation, notifying its insurer, and contacting its attorney. So by doing those things, the hospital basically conceded that it was aware there could be a dispute over this birth, and at that point the duty should have arisen whether they had heard from the plaintiffs or not. Now that decision is not particularly groundbreaking from people that practice in federal court, because that's been the federal rule in the 11th Circuit all along, that the party there are other external factors can give rise to the duty to preserve. But the impact of this on Georgia cases is it really expands the duty to preserve. The party that's, if any time that there's a potential for litigation, it doesn't mean that the duty will arise, but the conduct of that party will be what determines whether the duty arises, not some triggering document that it receives from the other side. So it makes it much more fact-specific in Georgia. There's not a clear trigger anymore, which is a little bit harder to juggle. And then again, it's going to come down to how the parties and the attorneys conduct themselves And from an attorney perspective, I can tell you it means advising your client very early on to preserve documents, because if they've contacted you, even if they haven't been sued yet, there's a reasonable anticipation of litigation, most likely. So Phillips v. Harmon has upset the apple cart in Georgia a little bit, although, again, it's just making Georgia's rule consistent with the federal rule. States vary across the board on this, but most states are in line, and this is sort of Georgia catching up with the crowd. Now, once the duty to preserve has arisen, and I can tell you there's a good bit of litigation over that, but over when that duty arises. But another issue that's important is what is the scope of the duty to preserve, and this is going to be sort of the new battleground for duty to preserve. The Zubelake 4 opinion, we talked about Zubelake in the first lecture. These are some series of 5 opinions that came out of the Southern District of New York in 2003, 2004. Really sort of created the e-discovery frenzy. Basically, it's pretty common knowledge. All relevant documents, including ESI, in the possession, custody, or control of a party, regardless of location, must be preserved. And you know, that is pretty broad and intended to be pretty broad. But there's obviously the dispute: what constitutes possession, custody, or control? And when you're dealing with ESI, there are certainly some new wrinkles to that determination. One of which is third-party outsourcing the IT function. Many companies are doing this now, particularly the smaller to mid-sized companies that can't afford their own data centers and the IT personnel. They'll hire third parties to come in and manage their documents, and so that all of the data actually resides off-site on somebody else's hardware. And that is not a basis for refusing to produce documents. The courts almost unanimously will hold that a third party that's keeping those documents by contract has a legal duty to provide them to the party, and therefore those documents are in the custody and control of that party and have to be produced. But you do see some people resist that particular information. What gets interesting in that front are emails and certain types of industry-specific data where the third party, where I guess the company or the litigant that's isn't the only person that owns the property. For instance, a lot of corporations still allow their employees to use their personal email addresses for business reasons. And so although the email content is related to the business, it's being stored by that employee's third-party provider. And the company doesn't have any contractual relation with the third party, really doesn't have a right to demand those documents at all. So you can imagine that gets pretty hairy. I mean, what the company can do, in theory, just as a practical point, is to ask the employee to hand over those documents. But a lot of times companies will say, no, we don't have to do that. You have to subpoena those records. Even though there are records, you have to subpoena them from the employee or from the employee's third-party provider. And whether or not you would be successful in obtaining those documents from the employer would really depend on the amount of control the employer exerted, whether the employer required this employee to set up this third-party email or encouraged it. There's all kinds of factors, and again, it varies on whether or not that would be the case. So you can see that's a little bit of a wrinkle in possession, custody, or control. Cloud services, very similar, really kind of the same thing. A lot of companies will store data in the cloud. They will make reporting, particularly drug companies do a lot of reporting on their sales. They do reporting on their research. That reporting gets sent to a government database where it's stored. The question is, what does the company control? What do the other people control? Again, it's a fact-based analysis for possession, custody, and control. Generally, we don't, as a practice pointer, and I think the way the cases will go, is if it's your business data, and if you can request the data for the company to review or for the party, the litigant, for business purposes, then you're going to be found to have a duty to produce that information in the litigation. BYOD is another wrinkle to possession, custody, and control that is really sort of a hot topic right now. BYOD just means bring your own device. For a while, corporations, law firms too, for that matter, were issuing their employees BlackBerries or smartphones so that they could conduct business and always have their email accessible and could work 24/7. It's really a nightmare. But the trend is moving away from that because there's a great deal of expense of supplying all of that hardware. And so what companies have started to do is create bring your own device policies where everybody uses their own personal cell phone. They just have the capacity to get their business emails on that phone, and in some cases their business text messages if the company has a business text application. And so the question then is, who controls that data? If the device belongs to the employee and not the company, even though it's company data, who controls the information? And quite frankly, the courts have been pretty stout so far in defending the individual privacy rights of the employees and preventing access to their devices in order to get business data off. Now, again, as a practical workaround, the employer can request, presumably the employee would provide, but if there's a dispute between the two, between the employee and the employer, you're really sort of getting into gray area for which there's not a lot of case law indication. I can tell you that most of the cases right now will basically require whoever is trying to get the information, seek information from the personal device to have some sort of basis for showing that there is in fact relevant information there. So there's frowning upon phishing expeditions onto personal devices. But if you have some evidence that there is, or some good reason to believe there is responsive evidence on that device, the court will allow it. But they require you to make the showing. One of the sort of newer developments in BYOD is information management systems or software, or wrappers as they're sometimes referred to, which the company can install require the individuals to install on their phones, which segregate work data from personal data, and that type of software gives the employer access to all of their work data on the phone, but not the personal data. And that allows employers to pull that data remotely without even having to get permission from the employee. And usually the employee signs an agreement early on that says, I give you permission to do that, which is a workaround, but it clearly is showing that in those scenarios, there's no question that the employer has possession, custody, or control of the data on that device. And quite frankly, corporations are doing that because they're generally losing the battles when they argue that that's not our data, it's on their phone, we have no access to it. So, and rather than get into litigation over that, into a tussle with their employees, they are having employees sign policies that give the right to the corporation to retrieve that data in the event of litigation. So BYOD is an interesting wrinkle. It's a new area. There's not a lot of case law guidance. Courts are clearly trying to be observant of personal privacy, but there's still many chapters to be written on that subject. Another question when it comes to the scope of the duty to preserve is not reasonably accessible ESI. And what that means is that basically, under the rules, the parties are required to produce information that's reasonably accessible, and essentially can take the position that certain information is not reasonably accessible and does not have to be produced in litigation. And the question then is, does it have to be preserved? And usually this topic involves backup tapes, and particularly disaster recovery backup tapes, where there's probably a copy of the data that's relevant on those backup tapes, but it would be cost prohibitive to set them up and retrieve that data. So is there an obligation then to preserve it? Most backup tape systems circulate so that they'll keep backups for 7 days or a month, and then it rolls off, and those older than that gets deleted, and those tapes are reused for new data. Does the litigant have an obligation to preserve that information? It depends, and the answer is going to be if the company knows that there is potentially relevant information in these not reasonably accessible sources of ESI, it does have a duty to preserve it. Now, that doesn't necessarily mean it has a duty to produce it, but it should stop any deletion and let the attorneys fight over whether or not it has to be produced. But at least if you've stopped the destruction of the data, then there's little risk of spoliation and sanctions down the road. It's again, an area of law that is not fully developed yet, so there's going to be a lot of room out there for you guys to make law on this as you move out into practice. Proportionality, again, introduced in the new, it's always been in the rules, but has been sort of reintroduced in the new amendments to the federal rules. And the deal is now that you can only discover information that's relevant to the claims and defenses and proportional to the needs of the case. And that relates to production, though. So does proportionality extend to preservation? And the answer is yes. Corporation can or any litigant can successfully argue that it shouldn't have to preserve information that is just out of proportion to the needs of the case. But case law on this is pretty scant right now, and so there's going to be a good bit of argument. And really the challenge is going to be on, it depends on the court, but we hope that there's going to be a consideration of the same factors that you see in determining whether or not the information is discoverable. And whether or not it has to be preserved, I can tell you that as a general rule, there's going to be there will be a tendency to require preservation, just because preservation allows you to come back and revisit. A lot of times in determining proportionality on the front end, it's difficult to know the scope of the claims of the case at the outset when the decisions to preserve are being made. And so the safer course of action is to preserve very broadly. And then you can argue about what you have to produce from within that large data set of preservation. But there is going to be argument heard on whether or not certain data has to be preserved based on proportionality factors. And again, that's going to be something interesting to watch develop this year and in the coming years, now that the rule has changed and that's moved up to the forefront of everybody's mind. Breaching the duty to preserve. So we know when it arises, it's reasonable anticipation of litigation. The scope of it is really anything relevant, although maybe limited by the proportionality factors in the possession, custody, and control of the litigant. Breaching the duty most courts have said that failing to preserve evidence is not in and of itself a basis for sanctions, but failing to have good preservation practices is a factor to consider when determining whether sanctions are appropriate. And 9 times out of 10 where this comes up is a case where a party just doesn't have, didn't send out a litigation hold, didn't manage their litigation hold, didn't update their litigation hold, and we're going to talk about litigation holds in more detail in just a second. But failing to observe good preservation practices is usually a sign courts are going to look, they usually look to punish that because corporations and attorneys have an obligation to make sure that good preservation is in place. And so failing to do so, the court's going to take some sort of action. Failing to preserve is the #1 cause of sanctions, not just for litigants, but for their attorneys as well. So it's important to understand how to execute the duty to preserve. As an attorney, you really have to be able to figure out when the duty arises, what information falls within the duty, and then put into place a plan to make sure that that data is preserved for the case. And it's not just your client with the skin in the game, it's also going to be you. So how to preserve ESI? There's a couple of ways. The 2 major ways to preserve the data, once you've figured out what it is preservation in place and preservation by collection. And those 2 are fairly self-explanatory. Preservation in place means you're not going to disturb the ESI. You're going to leave it where it is. It's going to take steps to make sure nothing happens to it and that it's there and accessible as needed for the litigation. Preservation by collection means going in and making copies of the data, pulling it out so that it can't be lost, and that usually it falls within the custody of the attorneys at that point, and can be accessed and argued over and whatever used for the litigation without any risk that the business will or the client will do something to damage or lose the data going forward. And determining which type of preservation to use is really, again, fact specific. A couple of questions to ask: is the data at risk of being overwritten, deleted, or corrupted? If it's data that's active data that's used regularly, that's updated regularly, and what's relevant is a particular snapshot, then it's better to preserve by collection. Go in and take the snapshot early in the case, so that whatever additional business that's done or additional changes to that information downstream from there that aren't relevant to litigation, those changes don't have to stop, but at the same time they don't damage the relevant information. And this is usually the case for database information that you see. A lot of companies keep client data in massive databases, but it can also be just spreadsheets that the accountant updates, or even your checkbook for that matter, if it's done like remotely. Updating amounts. Anytime that there's data entry that can change the data in the database or the spreadsheet, there's a risk that you're going to overwrite or corrupt the old data, the relevant data. And in those situations, preservation by collection is preferred. Another question is, do you trust the custodians of the data? If you send out a litigation hold letter to the employees who keep the relevant data, can you trust them? Sometimes one or more of your custodians is accused of some sort of improper act that's the basis of the litigation. They have an interest in making sure that certain documents aren't found, or that certain documents appear differently than they actually do. In those cases, you would preserve by collection, get the data out of their hands, away from their ability to alter it. But if that's not the case, the individual custodians aren't implicated at all, they're just doing their job, and there's no reason to doubt them, then preservation in place can make sense. You just instruct the employees, don't delete this information. There's no reason to believe that they would. Preservation in place is satisfactory. And then, is the data still being used? That kind of gets back to the overwritten, deletion, or corrupted. But another consideration there is that corporations, in particular, even small businesses, are in the business of doing business. I mean, it seems silly to say it, but despite litigation, their world does not stop. They've got to continue to move on. And so sometimes locking down their data for litigation is a real problem. And in those situations, a quick in and out preservation by collection is a business benefit to the client. We're going to come in, we're going to get all the stuff we need, and then you can go about your business. And so that's another instance where you might use a preservation by collection. So those are sort of the two general theories about how to preserve ESI. There's a lot more in the details there, obviously, but that's the theories behind it. So, litigation hold. Once you've identified the data, you have to come up with a plan to preserve it. And the plan to preserve it is called a litigation hold. And what you'll encounter, initially at least, in your practices, is that there's still a lot of attorneys out here who believe that a litigation hold is a letter that they send to their client or to the other side saying you need to preserve all relevant data. Litigation hold is definitely not a letter. It is a process, and the courts have been crystal clear on this. The act of sending a hold letter at the beginning of litigation is not enough for a litigant to satisfy its litigation hold or preservation obligations. And for the simple reason is that the letter is very static, and it represents an understanding of the case at the outset. And that's going to change as the case goes on. In particular, if you're dealing with litigation involving companies, custodians change, employees come and go. Data systems change as computers get updated. Sometimes the claims in the litigation change. What you thought were going to be the claims may change. New claims may be added, or claims may be dropped. So that litigation hold, as you framed it in your, and this is a duty that the attorneys have in your litigation hold letter, That's going to change, and so it has to be managed as it goes on through updates, um, through having contacts, a point of contact, making it interactive. So let's look at what an effective litigation hold will involve. First of all, you got to preserve all potentially discoverable information, so it should cast a very broad net. I sometimes have to explain to my very unhappy client why the litigation hold is so broad, because every client believes that their information that's relevant to the case is very narrow, because they don't necessarily view the case the same way their opponents do. And as an attorney, it's your job to understand the case, to see it as an objective observer and figure out what is reasonable in terms of the scope, and make sure that you've cast a broad net, because you're really protecting the client. And the argument to the client is, look, we're not agreeing to produce any of this. What we're doing is internally saying this is what we're going to keep just in case. And obviously, we'll argue that the production is a much narrower subset of this information. But the hold itself needs to cast a broad net to try to make sure, and you can come back and narrow it. If you view your litigation hold as a process, you can expand it or narrow it as the case goes on, but always better to be narrowing than expanding. Being interactive, confirming understanding and compliance. A lot of times attorneys will send a litigation hold letter and think that's it, check the box and move on. But how do you know that the recipients understand it? One thing that I strongly recommend is that litigation hold letters use common language, not to be particularly burdened with legalese. Try not to be too technical, although sometimes that's difficult. And usually require some sort of, I'll show you an example in just a minute of one of our templates that we use. But it has a form that the recipients of the hold letter basically fill out that show that they acknowledge that they received it, that they understood the hold, and that they complied with it. And that type of documentation is important, because later on in the case, the company is going to need to be able to show that it took, or any litigant really, that they took reasonable steps, that they understood their obligations, and that they complied with them. Staying current, that just means staying up to date with the developments in the case. If the scope needs to be narrowed, narrow it with a follow-up litigation hold. If there are new employees that are added, they need to get, they could have potentially relevant information, you include them. If there are employees or custodians who leave or are moving away, or potentially you're going to lose their data, making some step to capture that data, to collect it so that you'll have it even after they leave. And we do a 6-month follow-up. It can be 3 months, it can be a year, but just as a matter of course, whatever is reasonable for that client, following up with them, say, hey, don't forget, just a reminder, this case is going on, you're still under a duty to preserve information. That type of interactive, steady access is what the courts are looking for from a litigation hold perspective. Now, the last little bullet point I have here is to be minimally invasive. And this is just being mindful of your clients. I mean, you could do a gold standard Cadillac litigation hold process that can shut down a business because nobody can touch any data. The goal is to preserve the data that needs to be preserved and make it as least burdensome and invasive on your client as possible. So, and that really is where, as an attorney understanding e-discovery, you can add a lot of value to your client, or to, if you're working at a firm, to the partners there, is to helping them figure out a litigation hold procedure that's going to, is not going to upset the client too much. One thing that I don't have up here, which is important, is having a point of contact. Generally speaking, I like for companies to have a point of contact internally, because I think employee custodians generally are more likely to call someone they know in-house than to call the company's attorney if they have a question. So we usually designate a contact inside the company to be the person to answer questions, to make sure that the forms are returned, make sure that the procedure is being followed, and then we interact with that contact to make sure things are moving along as they should be. But there's lots of ways to do it, but having a contact internally is a good idea, or the attorney can be the contact. And that's effective, particularly if there's a smaller company where they don't have somebody that can do that as part of their job internally. Documentation of this whole process is essential to defensibility. I guarantee you at some point you will do all the steps that you're supposed to do to make sure that your client has preserved the data. You're going to get into a deposition, and one of the witnesses who you probably talked to specifically about preservation is going to say that they don't recall ever having talked about it, or they don't recall if they preserved this or they preserved that. And the other side will beat you up with it unless you can produce information or refresh your client's memory that, yes, in fact, we did talk about that, and I did take these steps to preserve. And so documenting each of these steps is important to do. Now, it can be burdensome. Internally, the client can document it. We document it with litigation project managers who are basically, they keep calendars about when the updates need to go out, keep folders to make sure that all the custodians have responded, that they received their hold notice, those types of things. You can be as detailed as you want to be, but generally speaking, any decision to save some data or not save other data should be documented, because you may have to argue why you made that decision. In litigation that runs on a 2 or 3 or 4 year cycle, it's hard to remember some of those decisions down the road. So documentation is a pain in the neck, but it's important to your litigation hold being defensible. Now, litigation hold notices. What does the litigation hold notice need to contain? And there's really three parts of a litigation hold notice. It needs to identify the data at issue. It needs to notify the right people, the custodians, and there needs to be some sort of verification mechanism. So the identification, basically, you can't guess, or you never will know all of the relevant documents on the front end of a litigation hold. So you address issues, date ranges if you can. That's helpful. The particular custodians and the repositories where the data may be. And you include that information in the litigation hold notice, because it's the instructions for these custodians. What is it that I'm supposed to be preserving to protect the client? It needs to be information that they can understand. Notifying is letting them know, what data is being sought, giving instructions on how to preserve it. That's a big one that often gets overlooked, and a lot of times it's because attorneys don't know. And if you're lucky enough to work for a firm that has an IT department, they can sort of help you draft this portion of it. If not, you need to understand basically what's a good way to preserve emails? What's a good way to preserve these documents so that we're not corrupting the metadata? And I hope I will get a chance to bring my IT guys down and meet with everybody, and we can talk about some of the very specific how-tos so that you will understand that and can include that information into your litigation hold notices. There's a big issue with emails. A lot of people just want to forward the relevant emails to the attorney, and that messes up the metadata. There's a much better way to do it. Generally, you can create a litigation folder it depends on the type of email system they're using, but for Outlook in particular, we'll set up a folder they can drag and drop to there. Then we create a PST and withdraw the information. But we'll get into more detailed specifics of how to do that when we get to collection. But giving the instructions on how to collect or how to preserve here is important to be in your letter. And then again, like I said, identifying a contact person. The verification is just a confirmation of receipt, a confirmation of understanding. One of the things that we do, although you don't have to do, there's no right or wrong or perfect form for litigation hold, but we created a bunch of check boxes, and I'll show you those, where we and put a place on the form for the custodian to put a check mark or a date when they've searched this particular repository and whether they found anything or not. If they're aware of any information that's been deleted, let's get that identified up front. So what I want to do now is let's take a look at this sample hold. There we go. So, and I hope everybody can see that. This is a sample litigation hold notice, and I'll upload all of this as well so you can see. And again, no magic words. This one, in fact, could be better in my opinion. This may be a little too much. It really depends on your audience. But so let's look at it. Essentially, litigation hold notice. We ask that it would indicate that it's attorney-client privileged, and they generally are considered attorney-client privileged. However, you can discover litigation hold notices if there is some sort of factual reason to believe that the data wasn't preserved as it should have been. At that point, courts will entertain the notion that they can discover this information. But as a general rule, they're considered attorney-client privileged and/or work product. We indicate on there, please do not forward, and that's simply because courts have found that the preservation, the attorney-client privilege is waived if there's no effort made to sort of contain this document. If it's just sent out with no instructions or indication to keep it private, then you are waiving your privilege. So we include that information as well. But anyway, just so there's information on the front end about the case, who the parties are, what it's about. The custodians need to know so that they can do the analysis in their head, what's relevant, what's not. Okay. There's some instructions about litigation holds in general. Underlining, lots of bolding, letting them know, down here, do not attempt to collect on your own. You're supposed to identify it, and then we'll come collect it. Okay. Information here, here's where in this next section in red, this is where the attorneys, when they get this, will go in and they'll write essentially a list of the documents or a description of the categories of documents that are potentially relevant and need to be preserved. So that's going to be very case specific. Relevant time periods, all of that information is there. Litigation hold acknowledgement, you'll see that there is a form, and this is it. The litigation hold acknowledgement and preservation certification. And it just says, I've received, read, and understood the litigation hold notice, so on and so forth. And then here's our checkbox, which I've found to be very effective. It can be burdensome, and some people don't like to do it, but it shows that the location that these individual custodians have searched, their hard drives, removable media, any other electronic files, let them indicate the date that they searched, and then just to check whether they found responsive information or not. All of that information allows us to argue, or to assess whether or not we've collected all of the relevant data, and then they sign it down below and date it. This type of form is, again, no magic words, but there needs to be something like this that goes out, quite frankly, in every single case. And it doesn't have to be this formal. It can be just a letter format, but there needs to be litigation hold to go out in every single case these days. Now, this is the hold notice that we send to our clients. There's another way that this plays out, and this is litigation hold letters sent to opposing counsel. And I'll show you this one. This one isn't one that we wrote. This is a good example of what not to do, although I'm not going to say that the firm didn't do a good job. What this firm did is what you'll see very typically, which is and we're not going to go through every page of it here, but you should read it. This is a case of a firm, I think, that is really a sort of a kitchen sink litigation hold. So this was a case involving a building that had a mold infestation, and the lawsuit was over mold infestation. And I assume one of these attorneys had been to an e-discovery CLE and had gotten a template, or really just sort of, or somewhere they got a form letter, what I call like sort of a kitchen sink litigation hold. And it basically tells our client in this case, look, you've got a duty to preserve, and it just starts listing, and it goes on and on and on. And this is mold infestation, and they want us to preserve archive data, legacy data, animations, images, audio and video, all sorts of things that really have nothing to do with the case, that are way beyond the scope of the case. And it's not customized to the litigation. it's my strong recommendation to each of you that your litigation hold notices to your client and to the opposing party need to be customized as best you can and to the needs of the case. When you send out something like this, which just says save everything you've ever created from the beginning of time, you're going to get objections, and rightfully so. This is overbroad. They want us to save hardware that's no longer being used. Told us that we have to maintain a log documenting all alterations and deletions to any electronic data storage device. I mean, it's over the top, and I don't know, again, where this person got this, but this is not the way to write a litigation hold letter. It's not save everything all time, because that's just not the standard. It's not proportional to the case. It's seeking information that's not relevant. It asks for the preservation of temporary internet files and cache files. Here we go, cookies. I mean, I can't imagine what cookie could possibly have to do with a mold infestation in a building. And so when you write a letter like this, a litigation hold notice that isn't customized to the case, what you get is a letter like this, which was our response. And we basically say that we are preserving according to our obligations and that we are not doing all of these things, and kind of went through their letter and pointed out all the things that we are not required to do. Now, practice tip for you guys and gals is that when you get a preservation notice from the other side, even if it's just sort of blustery posturing, can't ignore it, because what will happen is that the previous letter that we looked at requesting everything under the sun, if you have no response at all, and anything on that list, anything that was included in their letter turns out to be deleted, they're going to argue that you agreed, because you didn't object, to preserve that information, and then you didn't do it. And when I see a litigation hold notice like the one we looked at before, this very overbroad, over-inclusive hold notice, to me this is a warning sign that this is an attorney that intends to try to win this case in discovery by creating an unreasonable burden of preservation and production in the hope that either they'll drive up the cost or they've made it almost impossible to comply 100%. I mean, CAD drawings for mold infestation, ridiculous stuff here. But if your client doesn't preserve it all and you haven't objected, they're going to argue spoliation. And they clearly are keyed into it because you've gotten a warning notice early in the case. So it's important to respond and to let them know, look, this is what we will agree to do, which is generally, we're pretty generic about it, preserve information as required under the rules. And these are the things that we are specifically not going to do. And by responding in this way, you put the ball back in their court. If they don't object immediately to the court to say to try to make us, compel us to do these things, then our response will be, look, we told you we weren't going to do it. We never heard back, and so we assumed that that was okay with you. I mean, you sort of acquiesced by your silence. So it's a letter writing war, which you guys will all be engaged in soon enough. But it's important when you get those hold notices to respond. Don't get bullied by a litigation hold notice from opposing party. And then when you're writing your own, you'll notice at the tail end of it, we flipped it back and said, okay, now your clients also have the duties, and then we listed the documents that we expected them to keep and tried to customize it to the case as best we could, which makes it more difficult to object to. So I'm going to include both of these letters. I'll put copies just so you can read them. That was kind of a quick overview, and probably not easy to digest, but they'll be uploaded and you guys can look at them and study them and understand that this is part of the practice of law now. And one of the things that you should be able to do at the end of this class with some confidence and do it well. I hope so. So let's see. That's going to be pretty much it for today. It leaves us about 10 minutes though, so if any of you have any questions, now would be a good time. Again, there's always going to be a lot of information trying to cram into an hour here, so feel free to ask questions. You can either type them or you can ask them live. So I'll give you guys a minute to think about that. Okay, if you think of a question Also, obviously, you can email me at any time, and I'll respond. Okay. All right. Well, I appreciate everybody listening today. It's an important subject. It's one that is really the bedrock of everything that comes next. Is good preservation. If the preservation's good, there's nothing that happens in e-discovery that can't be fixed, and short of being sanctioned. If the preservation is bad, then you're playing with fire. So getting the preservation right is important. Then feel free to ask questions about it going forward, and we'll touch on this again, because this is the foundation of everything that comes later in the EDRM. So I appreciate your time. I look forward to talking with you guys next week.